We're talking today about tackling barriers to accountability, which is obviously a really crucial topic at the forum over the 2 days that we've been gathering. So we have an amazing lineup of high-profile speakers here today, and while their bios are in your packs, as I understand it, I might start with a few brief intros. So to my left, we have David Hillard, who is a pro bono partner at Clayton and who has acted for over 15 years in Australian courts to obtain remedies for people who have been victims of modern slavery. Then to David's left, we have Freya Dinshaw, who is an Associate Director at the Human Rights Law Centre, where her work focuses on deploying advocacy, strategic litigation, and international mechanisms to challenge the treatment of marginalised communities by governments and by companies. To Freya's left, we have Julianna, who is a lived experience survivor advocate and an expert by experience of exit trafficking, forced marriage, and domestic servitude, having not left a forced marriage but survived. Her goal is to inspire her children, provide them with opportunities she never had, and impart valuable lessons that will help them to grow up with pride and with confidence. She is a passionate advocate dedicated to preventing forced marriages, and her lived experience is a driving force for awareness, prevention, and policy reform in addressing modern slavery in Australia. Julianna's lived experience fuels her commitment to creating meaningful change for vulnerable individuals and empowering others to build safer and more informed communities. Thank you, Julianna. To Julianna's left, we have Thomas Costa, who is the Assistant Secretary of Unions New South Wales, where his responsibilities include managing the New South Wales peak work health and safety team and its research and industrial strategy. Thomas is also responsible for the coordination of the Union New South Wales Visa Assist project and migrant services team. Thanks, Thomas. So we'll jump into the questions for today. I'd like to start with you, David, because you've obviously got a lot of experience, as I mentioned, in finding solutions and finding remedies for your clients. And I wanted to understand, from your perspective and given your experience, has it become easier or has it become harder, or perhaps it hasn't changed whatsoever when it comes to achieving redress for victims of modern slavery over the years? Have you got any observations there?
Very simply, litigation to get damages for compensation for the consequence of what's happened in slavery is really not easy at all. I've been involved in quite a few civil slavery cases dating back probably a decade to Mr. Divya Kumar Trivedi, who owned the D&D Indian Fine Foods restaurant in Earlwood. And even today, I'm acting still for various people who've been trapped as domestic workers in the homes of foreign diplomats in Canberra. And all of those cases have been, we've used the Fair Work Act as a way of obtaining orders for clients and get them to be paid what they should have been paid under Australian employment laws. Usually the miscellaneous award covers domestic workers. And sometimes we get penalty orders for for people having breached Australia's workplace laws. Occasionally we're able to negotiate outcomes with people before we ever get to a judgment, and that's an excellent outcome, because the reality is that litigation is really hard. It hasn't got any easier in my experience. And the main issue, to speak as a boring lawyer, but we need to have someone to sue. You need to have somebody who is here in this jurisdiction, who has assets in this jurisdiction that you can enforce against. And in modern slavery, that's often not the case. I've been able to get some really enormous judgments in the federal court against former diplomats from India and from Sri Lanka for people who've been kept in modern slavery and as domestic servants inside the homes of those diplomats in Canberra, often working 7 days a week, 17 hours a day, without ever leaving home, without ever being paid. I've got some really lovely pieces of paper with some big numbers written on them. I can tell you now, I haven't been able to enforce those judgments against the perpetrators. And that's because these people are now former diplomats who have left Australia and who have no assets in the jurisdiction, and in reality it's very difficult for us to find a way to enforce those decisions. So the absolute best outcomes, which we've sort of stumbled across, and it's probably still a rare situation, but it's likely where someone who is a slaveholder, where they're an Australian citizen or where they're a resident here, where they own a home here. In 2023, Mr. and Mrs. Cannon, who were convicted and jailed by the Victorian Supreme Court for keeping our client as a slave in their home, they had as part of the conviction in the criminal matter, they had their house seized by the AFP, and we were able to negotiate with the Commonwealth Attorney General to get an extraordinary direction under the Proceeds of Crimes Act to have $500,000 paid to our client. It's very, very rare that despite getting what you see as public judgments and successes, that the civil courts are able to provide a proper financial remedy for people. That's a long way of saying, nah, it hasn't got any easier.
Yeah, I absolutely hear what you're saying, David. And in terms of the impact that the cases you've run have had, despite all those difficulties that you've raised, what are your observations about the impact when you have managed to achieve redress in some form?
First, in terms of human dignity, it's an affirmation to our clients that something wrong happened to them and it was unlawful, and that Australian law says that it's unlawful. That's crucially important. We've also been able to get some policy changes. There have been some substantial changes to the way in which DFAT issues visas for people to come and work as domestic workers in Canberra, I think directly as a result of some of those cases that have been run. But in the case of Mr. Suri Singh, who was the High Commissioner for India, he held our client in slavery in his home in Canberra. He'd been able to get a visa by simply saying to DFAT that our client was part of the High Commission's service staff, that she was effectively a diplomat, and she got a diplomatic visa. Now, there have been some policy changes at DFAT that means, and don't fall over with shock about this, but DFAT now requires, before issuing that type of visa, to see a contract of employment, to see a CV, to see that they require the person who's applying to be provided information about what their role is going to be and what their rights are. None of that's really existed back sort of 5-10 years ago. And so those sort of policy changes I think have been really important. It ensures that people who are kind of put forward as service staff and to get visas are not actually just someone who is really being brought out here to be a domestic worker inside the home of that particular diplomat. There are now requirements that Australian bank accounts be opened, that DFAT has an opportunity to meet with the worker once a year. None of those things sort of happened probably 10 years ago. So that's been, I hope, a sort of a structural change that's happened as a result of these cases, but I won't pretend that it's happened with our client or our individual clients also themselves receiving a significant personal remedy through that. It's been a broader sort of systemic change that's happened, but our clients have had to put a lot forward for not much by way of personal results.
Thank you for sharing that. And so, Freya, I might bring you into this conversation as well, because obviously David raised these barriers and these challenges, and one of the issues he talked about just before was the identification of a respondent to sue. And I know that you've been involved in a case against Kmart recently, where you've obviously found the respondent to sue. Would you mind bringing us up to speed with that case?
Yeah, sure, thanks. So in August this year, together with our partner for Morris Blackburn, we represented the Australian Uyghur Women's Tangrita Association to bring legal action against Kmart in the federal court. And so it's at the very early stage of the case, but I thought I would, for those of you in the room who aren't familiar with the situation of Uyghur people in Xinjiang in China, or East Turkestan as our clients call it, I thought I would just speak a little bit about the modern slavery issues there, and then also talk about what that means in terms of the action that they've brought. So for those of you who aren't aware, that for over a decade now, there's been credible, extensive evidence of widespread oppression of the Uyghur people and other Turkic Muslim minorities in the Xinjiang Uyghur Autonomous Region, or East Turkestan, in Western China. And we're talking about mass internments of over 1 million people, political indoctrination, separation of families, and an integral part of this system of oppression is sending people to work in factories, in farms, both within the region and across China, making, the clothes we wear, the shoes you buy, and, things from solar panel components to dates to canned tomatoes. This region of China has a lot of I think fertile land and a lot of produce and things come from there. And in fact, 85% of the cotton coming from China comes from the East Turkestan region, and 1 in 2 garments brought into Australia comes from China. So we are quite closely linked, I guess, to this system of oppression, and the UN has said that it may amount to crimes against humanity in terms of the scale and the level of atrocities that we've been seeing. And because the situation is so endemic, it really is nearly impossible to rule out the presence of forced labour or modern slavery in relation to products coming out of the East Turkestan region. So our client is a diaspora Australian grassroots community organisation, and all the women in the organisation have someone, whether it's friends, family, loved ones, who are still in East Turkestan. And so this is a very personal issue for them because, as our client said, we shouldn't have to look at a clothing tag in the shops and wonder if someone we knew was abused making it. And that's where this case against Kmart comes. So clients are concerned that 2 of the suppliers that have been listed on Kmart's factory list have credible links to the East Turkestan or Xinjiang region where this system of repression has been operating. And so they've brought what's called a preliminary discovery application against Kmart to essentially ask Kmart to be transparent about what checks and balances it's done in relation to the suppliers, what due diligence processes it's undertaken, in order to understand whether what Kmart said in relation to its ethical sourcing credentials is matched by its actions. And so that's a little bit about the action that they've brought.
Thank you for sharing. Julianna, I might have your views now. Thank you so much for joining us on the panel today. We're really, really grateful that you could be here. So my question for you is whether you think that victims of forced marriage can achieve justice through the criminal justice system in New South Wales as it stands at present. We'd be grateful for your views on that.
No worries. Thank you, Jade, and thank you everyone for giving me the opportunity to be on this panel. It's a simple saying no, because even though we do have the Commonwealth Criminal Act, it always fails to get prosecuted for forced marriages because there's a lot of challenges that comes in it. Either victims that are reluctant to come forward because there's one too many perpetrators involved. There's not only one. So we have a whole village coming to us. Protective orders, there is nothing to protect. There is no protective orders for forced marriages or any form of modern slavery. Everything protective orders that we do have are for ADVOs, which is more of a restraining order for violence. You need a very high proof of evidence to be proved beyond reasonable doubt within the courts, in order to be able to get them prosecuted. Yes, there is a common problem that's seen within each jurisdiction or within all the government bodies, is that there is a big, big problem, but our response is no one's talking about the solution. So there's always problems that's going to be discussed. How to tackle that problem is never discussed. There's always complex and cultural issues that comes into it. So you have the religious and cultural diversity that comes in, that once you leave, you bring more shame, you bring more restrictions, you bring more dangers, because that is the crucial time. Because when we leave, it's putting us more in danger and our lives are threatened. And mind you that most of us do have children with us. So going hotel hopping, state hopping, just to save ourselves, when it's clear to the government that the perpetrators are always known to the police, but yet they always fail us as survivors to get the prosecutions to happen. But also in the initial crisis, when we do leave and come forward, support needs are always not immediate. It's short term. And I can say firsthand that when we do get support, we have an issue with accommodation, economical independence as well, where we don't have a job, so it's easier for us to go back into the situation rather than leaving, because leaving makes it harder. Then we come to re-exploitation, and then we come back to taking advantage of our vulnerability. So because there are gaps within our systems, that we always tend to fall is like, well, I don't want to go against that current. I'd rather go back to my perpetrators because it's much easier, it's all known, because living is harder because no one bridging that gap for us. And one thing is that we go in isolation when we leave. We need a village to raise children, we need support. But even though our common civil society knows that there is someone going through something, they will never intervene. They know they have to do something, but they're limited to what they can do too, is that if they do intervene, how harmful will they be? So we don't have peer support. It's just recently that has come. But originally, when you do leave, you need that peer support from the beginning of your journey so that you don't feel alone, you don't feel isolated, you don't have to always repeat yourself when you're going through the criminal justice and reporting investigations or when you're giving statements with the police. That's where you get re-traumatized. So simple, I'm sorry, there's limited cases that has been prosecuted and you're very lucky to get that. But sometimes, even if you go report, they do tell you that unless something is happening, unless you're in a pool of blood, they're not going to do anything about it because they say, well, he hasn't done anything. They get bail easily as well. Bail is given very simply. And then you're endangering society, community, and civil society altogether. So you're traumatizing children. So if we don't break the cycle, we don't break the patterns, and we don't give support needs that is in a crucial crisis, needs that they do need. Children are always forgotten. So if you want a better future Australia, we need to incorporate services that are tailored specifically for children when they do come out of situations of any form of modern slavery, because there is nothing existing until they are at the age of 16 or you go through victim compensation. Again, that's another lengthy process. So if we don't give them the support at 16 and under ages for underage, then we are repeating the cycle, repeating the pattern.
Thank you so much for that. And I think you've just perfectly demonstrated why it's so valuable to have you on the panel to talk about those important things. I'm really grateful for your contribution there.
Thank you.
And if you're comfortable sort of continuing along this path, I might ask you, I mean, you spoke very eloquently about the solutions that are needed. Would one of those solutions look like training criminal justice actors on improved responses to modern slavery, or would it look like something else, do you think?
Yes, we can have training and having intersectional identification within the system. So even though we are limited with the modern slavery for support, how about we get the domestic and sexual violence, grab the support from others, but use the one service to provide it for the victim survivors? If policies have been created, I'm sure policies can also be changed. So when that comes in is that back, God knows how many years or whatever when the Act was out, does it suit for today's advancement? We're in 2025. I think it's another update to do with our legislation codes or with our policy reforms that is limiting support needs or provisions providers, service providers, to incorporate children or to give certain victim-based or support needs that are more tailored for victims that they require. If we can change that, then we do need training, cultural awareness, education with our support system, but we need to get into the schools. It's vital because that's where our children are. You are trained from a young age that this is what your life is going to look like. Just because our parents went through it, it doesn't mean that our children has to go through that. So we need to raise the voices. Just because they were not seen or heard, I can't do that to my children. My children need to be seen. They need to be heard. They need to talk the differences. They need to have the safe space that they have a choice, and we're here to support them, but we need our legal system to support that as well. So training within the schools, training within our state police, our first responders, whether it's the emergency department, our nurses, our doctors, our GPs, and having mandatory reporters and penalising them for it. We need harsher laws. We need better protective orders. I mean, the restraining orders at the moment is only for 2 years. It's not enough. We have a life lengthy of healing, and we're stuck. we are always trying to heal from and live with that scar that's always lived with us. Same way that if a flower is not flourishing, do we blame the plant or the environment? So if the system is not working with us, so how can we bridge those gaps in order for the system to work with us? So we have better prosecutions, we have more perpetrators behind bars, and we have more recognition for children to be a part of the process so that we have a better and brighter Australia.
Thank you so much for putting that forward. Yeah, please. Thank you. There's a lot of support in the room for what you've said, obviously. Thank you so much.
Thank you, everyone.
So Thomas, I might bring the discussion about migrant workers into the panel as well. With your experience, can you let us know whether you think there are particular barriers that migrant workers face here in securing justice for modern slavery and related exploitation relating to their work?
Yeah, sure. Probably, and this is going to sound a little trite, but the biggest barrier that migrant workers are facing, at least in our experience, is fear. Fear of deportation, fear that their visa is going to be cancelled, fear of authorities that are going to investigate them and their visa status. And that fear is not unwarranted. We have real evidence of people who do have their visas cancelled. They do get deported. And often because of situations that are not of their own making. There is a lot of myths out there that migrants consent to their own exploitation, that they are somehow fortunate just to be in the country, and therefore if they're paid below minimum wages or they're harassed at work or other things happen, well, they're still better off because they're in Australia and they're not in their home country, and so they've accepted somehow this type of treatment. And that's made it very easy for policymakers to design visas that further entrench that type of vulnerability. Every year we conduct a large-scale research project into the scale of workplace exploitation of migrant workers in specific different areas. Last year we focused on the experience of migrant women in workplaces in Australia, and we found over 70% of migrant women are sexually harassed or sexually assaulted at work. But the overwhelming majority of those, 61% of them, don't report. And the reason they don't report is fear, and it's fear about visas. Because their priority from our research is to remain in the country. And I don't think that is very surprising. I think all of us, our priority would be to remain in our home with our families. And that's the same thing that migrants are prioritising, and they put up with very extreme treatment because of that. I know that this is a very well-educated audience on these topics, but for those of you that don't know, our visa laws are very restrictive. Every type of visa has some form of restriction on the way people work. If you look at international students, for example, they're only allowed to work 24 hours a week. If they work anything more than that, they have breached their visa condition. Their visa can be cancelled, or a future visa can be refused. If the visa's cancelled, they have to leave the country or they're deported. That doesn't matter if they haven't been paid for that work. And so we've seen situations where migrant workers, international students, are brought into a job and they're told flat out, if you don't do 40 hours work, we're not going to pay you for 20 hours. And so they have to do this full week shift, and then they get paid half pay. And from that moment onwards, the employer owns them, because if they ever report that underpayment, the employers tell them straight up, well, we will report this to the Department of Home Affairs, you will be deported. There's been some recent reforms that are assisting us in protecting these workers, particularly around the workplace justice visa, but they don't go far enough, and we can talk about that later. But it's every visa class, it's not just international students. There's been a lot of talk earlier today about working holiday makers, the backpackers visa. These are not backpackers. We go out and talk to them. We talk to thousands of these workers. Not one of them has a backpack. These are not, it may have been 20, 30 years ago, people coming to Australia from Europe, getting in a van, driving around, working seasonally on the farms, backpacking. But that is not who these people are now. The overwhelming majority of them are guest workers. That's what it really is. It's a guest worker scheme. It's been opened up to a large number of countries, and people are coming here to work, and that's fine, and they should be able to come here to work. But there is a requirement on them that if they want to extend that visa, they have to work in a regional area in the horticulture industry for 88 days. And from talking to these migrants, that almost everyone accepts that that's going to be a terrible experience, that they will not be paid properly, that they may have to work a lot longer than that 88 days in order to get that employer to sign off on the fact that they have done 88 days. So 88 days in some cases turns into 6 months before the employer will sign it off as 88 days. And it will be long hours, back-breaking, dangerous work. And some people accept doing that in order to extend the visa. Like I said, the priority is often to remain in the country. Some often don't. But we need to kind of get away from the narrative that this is somehow an acceptable situation to create for people. It's torturous. In some cases, it leads to slavery or slave-like conditions. We often find that in the horticulture sector. And now there's the new phenomenon of PALM, being the PALM visa, which is a visa in which the migrant worker cannot actually change their employer. They are bonded to their employer permanently. And we're seeing that visa just being absolutely ratcheted up across a number of industries. It was originally used for the horticulture industry as seasonal work. We're now seeing it in meat processing, in abattoirs, in the care industry, and horrendous treatment of those workers. Very much like slavery, they bonded to their employer. If they complain, their employer dismisses them. They have to leave the country. It makes it very hard to represent those workers as well when they're offshore.
Thank you. Thank you for outlining that for us. In terms of sort of shifting the conversation a little bit in terms of, the role of the state government and potential solutions that might be available there, how do you see the state government coming in, and what might reform look like there?
Yeah, it's a complicated question because obviously the visa settings are a federal government issue, but there's still a lot the state government can do, and in some cases is doing. So the state government gave us a grant to set up a migrant worker centre, which will allow us to better engage with these workers and represent them, and I think that will help. But there's more in the options available to the state government. There now, like I mentioned earlier, is a workplace justice visa. It's not perfect, but it is helping a lot of workers. There's only a few organisations in New South Wales that can actually certify for someone to get a workplace justice visa. None of them are well funded. There's been a bit of federal money that's come out funding those organisations, including my own. But more funding for accredited third parties to do that certification would assist, because it would allow us to be getting out there and certifying a lot more visas, doing the due diligence on these people and allowing them to pursue their cases against bad employers. The other thing that I think is something the state government should consider is there is a work health and safety regulator in New South Wales called Safe Work. Their priority is to investigate safety at workplaces. They have investigative powers, they have right of entry powers, far sweeping powers that no other organisation has to go in and inspect that workplaces are safe. Traditionally, they have focused on dangerous industries like transport, construction, maritime, stevedoring and so forth. We really think that there should be a specific task force within Safe Work that actually focuses on migrant workers. They can get access to the data from the federal government about where migrants are going and working. We know the federal government knows where palm workers are. We know that's a high risk area for migrant workers. The New South Wales regulator really needs to be tooled up and focused on getting out to those sites and inspecting, because it's not just that these workers are not being paid properly, they are in extremely dangerous situations. We have had cases of people who've been severely injured. In one example, we represented a worker who had, through a workplace accident, injured his eye. The employer abandoned him. He ended up going blind in one eye, was about to be deported out of the country because the employer terminated his employment contract. His visa became invalid. This all of this should have been covered by workers' compensation. There should have been a regulator that investigated that workplace. That employer should have been prosecuted. None of that happened until we became involved. And that's just one case study, but there are many others similar situations like that.
Thank you for sharing that. And thank you for also sort of discussing the complexity of the federal legislative framework and the state-based, because obviously that's going to feed into any remedies that are sought. I might jump back to you, David, before I then move on to Freya and Julianna to follow. Along this line of what state tools are available and or could be available, David, I'd love to get your input on the efforts to try to use the New South Wales Victims' Rights Support Scheme as an existing tool, and is it working?
Is there anyone here from the New South Wales government? Great. The Victims Services in New South Wales Victims Services is a statutory compensation scheme for victims of acts of violence to obtain some level of recognition payment and other support. It was a much more generous scheme 15 years ago. It's, like most schemes around the country, now been reduced to very small amounts of money. About 3 years ago, there was an amendment to the legislation to include victims of modern slavery as people who are eligible to bring applications for recognition payments. Despite the legislation saying that, it in practice has not been an effective way for people who have been survivors of slavery to be able to obtain state compensation. Despite what I'm about to say, I think the solution is actually to build a better compensation scheme and to probably have one that's not necessarily state by state based, but that operates nationally. If you are going to be a victim of violence, you're much better off being a victim of violence for bringing a compensation claim in Western Australia than you are in New South Wales. The amounts of money that can be recovered are about 15 times higher in WA than they are here. There are a couple of really substantial problems, and someone put up a flag when I'm being too boring about this, but the first thing is that, flag already. The first thing is that in New South Wales you need to be the victim of an act of violence. A lot of slavery does not involve violence. It involves people being trapped for a whole range of reasons, but it doesn't meet the definition of violence as such. You can only bring the claim if you've been a victim of an act of violence, and it doesn't matter, therefore, whether you were also the victim of modern slavery. Including those words adds nothing. If you could bring a claim beforehand, you can bring a claim now. If you couldn't bring a claim beforehand, you can't bring a claim now. Secondly, the New South Wales and most of the national schemes that operate around the country are based on the idea that usually if someone has been the victim of repeated acts of violence, they will be treated as a single act of violence for compensation purposes. The thinking being, if you are the victim of domestic and family violence, that is a single act, whether that is something which has continued for years and years or occurred on just one occasion. When we're talking about slavery, we're often talking about multiple acts of violence, particularly in sex work. And in those circumstances, the default position in New South Wales is to say, well, all of those acts are going to be a single act of violence, meaning that if you have been through one assault or 400 assaults, you'll get the same amount of money. And in New South Wales, most of you will be shocked to know that that amount of compensation is $10,000. It's not fit for purpose. And rather than trying to squeeze modern slavery compensation or remedies into the New South Wales Victim Supports and Rights Scheme, actually I think the word rights might have just been taken out of the legislation this week in an amendment. I don't know what that means, but can't be good. Rather than trying to squeeze it into a scheme that's not built for it, I think there's a need for us to have a national form of statutory compensation scheme available for people who have experienced slavery to get compensation, regardless of whether that slavery was violent or not, to recognise the fact that it is an offence in Australia to keep someone as a slave, and there should therefore be a very obvious way of people being able to obtain statutory compensation. I'd rather not run any of these cases in court. It's long and cumbersome and difficult and is not going to be a useful experience for anyone. Statutory compensation schemes are what we need.
Thank you. And you mentioned remedy as part of that answer, David, and I thought I'd throw to Freya on the question of quite a broad question. I do apologise, but it's a really important one. What does remedy look like in this context, if you don't mind kicking that off?
Yeah, and it's a question that I often think about because, like David said, I feel like the courts provide one form of remedy, and often, as a lawyer, you're sort of thinking, well, remedy means that you're brought to a place where you're made whole again, or you have what you need to be restored to the place where you were before the wrong happened. That's like the test that we all learn at law school. But I think that, and I'm particularly interested in Juliana's perspectives on this. It's just such a different thing in real life. And when I talk to people who face often really harmful contact, or are living in very difficult circumstances, and often we work with communities abroad who are in these circumstances and are facing harm by Australian companies in particular, it can be very disheartening to kind of give advice around like pathways to justice and what that means in practice, because even talking to us is this act of re-traumatizing people, having to tell their story again and again. You hear it once and then you have to hear it again to take the notes and all that, and it's a very, I don't think it's a particularly humanizing process, and that's just the start of it before you even get to seeking a justice pathway. There's also the cost. They're not cheap cases or easy cases to run. There are cost risks, and often faced by people who aren't well placed to bear those risks. And then there's also a huge personal toll that you take to put the time and work into pursuing justice, I think. And so I think a pathway many don't choose because it is difficult and you're not sure what you're going to get when you get there. But at the end of the day, like justice, I think, and accountability do lead to healing. And so that's why we all do the work that we do. It's a really important tool. And also, you hope that it means, it will change outcomes for people later down the line. So it goes beyond one individual case to the system more broadly.
Thank you. And Juliana, the same question to you. We'd love to hear your views. What does remedy look like?
Changes in remedies, what will look like to me is early identifications, training within our first responders, within the schools, social workers, or even with judges as well, because there are certain judges that are unaware of what we have to go through in order to bring our case forward, and then we get criminalised within the system and get re-traumatised, especially when there's children involved. It's one thing leaving a situation, escaping, and going for a better life, and going with 2 children when you have 2 dependents and you've got more responsibilities on your shoulder. Which door are you going to knock down? Who is there that's going to assist in the process? We need more clearer pathways to be able to be accessible to us as well. Expanding and improving our victim support services as well. Like David said, with the victim compensation, it is much less in New South Wales compared to Western Australia, and it's not recognised enough that there is nothing. Where is accountability? Again, we need justice cannot be brought to us because we can't go back to what we have lost. For myself, my childhood's never going to come back, nor my youth. Those lives that I had lost, those years that are gone, I cannot get it back. But the least the system can do is hold them responsible, have the accountability. Those that wronged us, press charges. Why does it have to be so hard? And why is it being so difficult for them to do? When you know the perpetrator is known to the police, they are breaching. Why is it has to be 3 breaches and then you arrest them? It should be a breach that should happen when first time it happens. Apprehend them, because that's not supposed to do. That's our humanitarian right to live freely and move freely, but that's always restricted and that's always taken away from us. We don't have the freedom to move freely. We are constantly running for our lives to have a better life. Sometimes we forget ourselves and put our children first because they deserve better. They didn't choose this situation, and nor did we, but at least we're leaving that. Having better legal protection orders and justice outcomes as well, especially with those that are coming under spousal visas. And then when you leave your spouse due to a violent situation or acts of modern slavery, again, I think with Thomas said that the torment is going to come. It's like, oh, well, now I don't have a visa. How am I going to stay in Australia? So having a better visa pathways, knowing that because of the cohesion or because of our modern slavery situation, there should be a better pathway to obtain that without having to be linked to our perpetrators. Enhancing coordination and data sharing as well. So if lived experience is giving you people with victim survivors are coming forward and sharing their stories, that's already a data there. So have those sectors come together to share that data. So that way we have more prosecutions and we've got better statistics, and that's more accurate as well. Another one that's dear to me is survivor-centered policy development. We don't want lived survivor experience to come in as a consultation. We are beyond that. We are expertise. We fall between the cracks of the system. We know where the system is failing us, and I think everyone in this room that are in the higher position anyway, everyone knows the problem, but no one is thinking of a solution. So if we have a collective voice coming forward telling you what are the cracks and what are the problems, take off the problematic hat, put on a solution, more future solution-based, that I know nothing's going to come for me, but I want to have better policies, better reforms, and better legal protections for our future survivors to come through as well. So include us not only in consultations, co-design, co-delivery, implementation, measures, and sorry, I'll take that.
No, take your time, absolutely.
Because through our lived experience and when we come forward, we can be the change with those policies. At the moment, incorporating inclusions of cultural awareness, but what does cultural safety and cultural awareness look like? Our state police don't have enough training. Something that's more common in my culture that is normalized for us is not normalized here. So when we do go reporting, it's like, oh, another diverse person, they have the same problem, it's just another day. But take that serious, because it comes with a lot of, it takes a lot of courage. We come with dignity to tell you guys and report, but if we don't get the first response from you guys, and sometimes just an ear to listen, you'll never know that cause of problem. And have more of survivor leadership. So again, that comes to having economical, having positions within the government as a lived experience, so that the lived expertise are throughout the whole process as well. So something to do with survivors coming in and letting our government policies know that these are the gaps, these are things, so this is where we're failing, so what's not working, work on those, but what is working, just keep it going. Having something long term, not short term. So if we know that we're going to be tackling this higher statistics and higher numbers of forced marriages coming forward, so who are the point of contact audience there? So go into the schools, high schools, incorporate more mandatory reporters that can actually report, but in those that fail to report, penalise them as well, because forced marriage is illegal. We do have a legislation act now as well. So, and those that do fall in, that are within the scopes of that. So train, raise more awareness. Don't have billboards saying if any suspicious activity, please report, because sometimes we don't know who we're reporting to. But if we're going to have campaigns like that, we have the one number that we can call, or knowing who our safe body is that is willing to report. When we do report, they're willing to bring that change and take action. So as it is a bureaucratic system, we are a reactive system, not a proactive either. So we need to hold those responsible, and we would like to see more change and work towards a prevention, not towards focusing on a problem. So if we want prevention, we need all sectors to work together, not against each other, and don't go into silos. So it's a teamwork. So building a better policy together.
Thank you so much. It's such an important question, isn't it? And Thomas, do you have anything to add to the question of what is remedy from your perspective?
I think what you said about pathways to permanency is really important. I think there clearly is a problem in the entire system where people are forced to go through like an obstacle course of visas where there's no clear pattern on which ones to take at any point in time in order to get permanent residency. And so whether you're dependent on an employer or you're dependent on a partner for your visa, you're constantly kind of grappling through that obstacle course until you get permanent residency, and often waiting till you get that permanent residency to take action. And we see that with the workplace exploitation, where people will put up with very extreme exploitation, sometimes not paid at all for years because they've been promised that they're going to get permanent residency. We had a situation in Canberra, a group of 5 massage therapists. They were essentially imprisoned in the employer's house. He would feed them out of a dog bowl, would chain up their rooms at night. They had to ask for permission to go to the bathroom. They were in that situation for 5 years before it came to our attention through one of our union affiliates, and we were able to intervene, and with the assistance of the Immigration Advice and Rights Centre, which we work with a lot, we were able to assist these women. But they had been promised eventually to get permanent residency. As soon as they had been rescued, their employer cancelled their employment, and they actually became unlawful because their visas expired. They hadn't been told about that. Their passports had been confiscated. The only mechanism that was available to them to remain in the country was ministerial intervention, and we had to go to the minister a number of times. We went to the previous immigration minister under the previous government, under a Liberal government, who continued to refuse, and then the election of the new government and the new minister, Andrew Giles, was when we were able to get that intervention. But so much of these situations are tied up in that journey to permanent residency. A much clearer system which said, if you've been here 4 years, you've lived here, you've done everything right, you get a permanent visa, would make things so much simpler and easier for people to go and pursue remedies.
Thank you. Thanks, Thomas. One of the points that Julianna raised was the importance of having data and more information gathering to assist with these claims and these important remedies, or seeking of remedies. What's your view on sort of the proliferation of AI and how that might be used in this context to assist?
I think all of us get really excited about AI. My organisation's very excited about it. We're hoping it's going to solve every problem that we have. Over the past 7 years, more specifically, like looking at what we've looked at, over the past 7 years, we conduct an audit of job ads in foreign languages, and so we go through the common sites like Seek and Facebook, but we also go through a lot of closed community groups where jobs are advertised. And we've been doing that manually. So we bring in activists who speak the language, who are able to read the ads, call the employers in language, confirm what's on offer, and then we publish a report about it each year to give us sort of an idea of how widespread offers of exploitation are. Recently, the Fair Work Ombudsman announced that they're going to build like an AI bot that's going to just crawl through the internet and identify all of this, which I think is a great idea, and if it works, fantastic. But we have real doubts about the ability of it to be able to work effectively because of the nuance of language. And it was talked about in the session before about just the nuance within the English language, and business and unions and governments all speaking a different type of English language and not being able to communicate. So you can imagine how complicated it is when you add foreign languages and all the nuances within those languages between formal and informal and different things. So I think we're still going to need real people on the ground constantly looking into these matters. I think trust is also a big issue. So much of what we do involves building a relationship of trust with migrant workers before we can then go and advocate for them. I don't see AI being able to do that yet. The Migrant Worker Centre that we're establishing is run by migrants for migrants, and a big part of that is because we understand that in order to build trust with the communities, people have to come from those communities. They've got to speak the language, and yeah, I'm looking forward to AI helping us create efficiencies at work and making us the money that we have, the limited resources we have, go further. But I don't think it's at the stage yet where it can actually do the core business of the organising and the advocacy of these communities yet.
Thank you. Thank you. David, do you have similar views on AI
Oh,
in your practice?
I think AI can be anything anyone wants to talk about it being at the moment. I haven't seen yet a lot of examples of what the potential is. We're talking a lot about potential, but in practice, it's really hard to say here is an example of something yet which is working or which will work. But I hope that none of my clients would prefer to speak to a bot than speak to myself or one of our lawyers. I can't see how you get to build a relationship of confidence talking to your ATM effectively. Like, I just think that it's crucial, as Thomas said, it's crucially important to have systems provided which have human contact to be able to do this, particularly when we're talking about the types of clients that we're discussing today. The idea that the solution is going to be something impersonal and online and that will work for everybody, I think is really, really hard to get my head around.
Thank you.
I'm also old, so I don't
No, age is no barrier. Freya, I might turn to a different topic, just especially given your expertise and your work at the Human Rights Law Centre. Obviously, there have been recent pushes for a New South Wales Human Rights Act, which has been under discussion for a long time. New South Wales Parliament has seen a bill of late. So I wondered, sort of, in its current absence, how do you frame a case without that human rights sort of framework to pin your cases on, and what could you see it changing? What could improve if we did have the Human Rights Act in New South Wales?
Yeah, so firstly I have to declare I'm a Victorian and we do have a charter. And actually, like, the way that the Human Rights Acts work typically is that they bind government rather than businesses. And so they impact what government can do and like public authorities, which includes, we heard a lot about what the New South Wales government is doing in terms of its own procurement and respect for human rights. And I think that the Human Rights Acts are really critical in creating, like a baseline of expectation around the business of the state and how our governments can legislate and what kinds of rules are and aren't permissible. But in terms of broader corporate accountability, I think what we would be, looking to in the longer run is something like what they're moving towards in Europe in mandatory human rights due diligence laws or something along those lines. But if you are interested in the Human Rights Act, Human Rights Law Centre does have a campaign for a federal Human Rights Act because Australia is the only Western democracy without one. So if you're interested in supporting that, go and sign it up on the website, and I'll pass on to my colleague that I've given the plug for that, because it's a big gap, and there's an opportunity now, I think, with the government to lay a bit of the framework so that people can be, some of these systemic issues that we're talking across that face so many parts of our society, whether it's homelessness, whether it's a failure to be able to access healthcare just because of the slot of the system you fit in, whatever it is, it just kind of ensures that all of us have that basic dignity, freedom, safety. So I think Human Rights Acts are really great. But in terms of operating in the absence of one, there are other tools available in the law, and we see them used all around the world, even where we're looking at standards of care, negligence claims. There's also in Australia the OECD National Contact Point, which is very little known except among a very small group of fans of it, where Australia, because we're a member of the OECD, we sign up to the Guidelines for Responsible Business Conduct, which are kind of baseline standards that require multinational companies to respect various human rights and environmental and competition and other standards. And so where there's a failure to do so, there are non-judicial ways to seek justice through that outcome if you can negotiate a good outcome with the company that has engaged in harmful conduct. But yeah, it is really limited, and so I do think reform is necessary. And the case that I spoke about earlier in some way illustrates some of the difficulties, because if our application currently is successful, it could pave the way towards a consumer law claim around misleading and deceptive conduct, which is an unusual way in a sense, to deal with an issue like modern slavery. And so reforming the Modern Slavery Act, so that workers or people who are in those conditions can actually access remedy directly through legislation would be a really positive step forward.
Some of the existing legislation. So the Fair Work Act is a fantastic piece of legislation in which that covers a lot of this space in terms of slavery in a work-based context. It's possible not just to get orders for what people should have been paid under the law, but it's also possible to get penalties. So again, enforcing them is another issue, but we've obtained penalties against 2 diplomats of $118,000 and $97,000 as additional sticks that the Fair Work Act has to whack employers with who've done the wrong thing. The Fair Work Act has been able to be used by us to recognise employment contracts that were made in a different country that were unlawful, that didn't recognise Australian conditions, and yet still used. Like there are lots of vehicles available. The ACL is another good example in existing Australian law to be able to bring and try and seek sort of remedies, bring actions in relation to people who've been through slavery. It's about sort of, I think, thinking creatively about some of those things until we get a Human Rights Act.
I'm so glad you jumped in there, because I was actually going to come back to you, David, on the point of strategic litigation before I return to Julianna. But it's such a good point that there is existing legislation, notwithstanding the fact that we do not have that human rights legislation. And so I did want to get your views, David, on the role of strategic litigation and how you've seen it sort of increase, if you have, and how it's having an impact in this space.
I think the sort of matter that Freya is describing, that the Human Rights Law Centre has been running, is a really good example of trying to think creatively about how do we bring shame through the public legal process against suppliers and employers who are doing the wrong thing. A lot of these matters are just simply about getting people access to representation and bringing existing remedies. I think my practice has probably acted for more than probably now close to 60 people who have been survivors of some form of slavery in Australia. And in every one of those matters, we've used very boring, dull, common pieces of legislation to try and get a remedy, whether it be through something as really as simple and benign as victims' compensation legislation, or through the Fair Work Act of, hey, if you do work in Australia, there's probably an award that covers that work. What does that award require you to be paid? Things like that. There are, it doesn't necessarily need big, exciting, glossy, legal, new, novel actions. There's a lot of, there actually is quite a lot of useful coverage under Australian law already. It's just being able to match people up who need legal assistance with people who can provide that legal assistance.
Although I think the exception to that is conduct outside of Australia, and that extraterritorial element to it. And so, for example, there's a large Australian manufacturer here, Ansell, who make the gloves, who are sued in US courts over conduct through one of their Malaysian glove suppliers, where the workers were in pretty atrocious conditions, bonded labour, etc. And we were sort of asked, well, why are they bringing the claim in the US when Ansell's an Australian company? And I think it's a good question, because it does just speak to different kind of ways of accountability and how countries sort of see their role in what standards they set for their businesses and the decisions that are made here and the processes that can be done here, notwithstanding that we have a globalised workforce and forms of exploitation can happen in any country, in any sector around the world.
Thank you. And you've mentioned obviously the cornerstone of all of this, which is accountability, and that's obviously a subject you touched on earlier, Julianna. Julianna, I just wanted to give you the space to let us know whether you've got any additional comments or additions to things you've already said, whether it's additional outcomes that you'd like to see for victims of modern slavery, or whether you've just got anything to add for the room.
One last thing that I would like to add is not only holding government bodies accountable, having some sort of measures in place for accountability, but also how we can work with our neighbouring countries as well when exit trafficking of any forms of modern slavery does occur. That can look like, because of underage, parents usually are the point of giving consent. Unless you have certain, if you have more custom or border force that is more trained, can actually read the body language of that individual. So you can actually see it at the border. Someone who can just look as normal as going for a holiday overseas. So if there is indicators there as an early identification, so that border force or customs officer can actually separate that family, put them into singular interview rooms, and just simply ask that underage victim, is like, what is the purpose of that holiday? If they are in alone without the perpetrators, they will automatically disclose that to them as well. So then that way we have those support people, support services come into and, you know, give that victim obviously some support, but also working with our neighbouring countries as well. Like if they are going to a certain country and they know that they have slipped out of the cracks within Australia, but how can that neighbouring country come to attention? So, and then they are notified and they are stopped and they can be sent back. So there are certain early intervention indicators there, but we need to have better laws, harsher penalties, better protective orders, and the system working together is my own keys that only then we can bring change. So don't work against each other, don't be in isolation, don't work as silos, but work together to bring that change. And meaning that I would love to see the state police and federal police working together to get more prosecutions done and better investigations. Don't go and approach the perpetrator before you do your evidence gatherings, because that's going to put us in a more higher risk. We need more better support services to work with us and give us that safety, so that in the beginning initial stages that we are in crisis and we are living, and it's against our autonomy and redirecting, because we came out of such a horrific experience that we didn't choose, trying to grasp and understand that it wasn't our fault. What we're doing is the right thing, so that we don't go back into repeating the patterns, repeating the cycle, where we want to put a break to that cycle and just be more empowering to that, but also know that there will be children involved, not because they want to be exploited, but they are usually a byproduct. They don't have the agency, they don't have the autonomy, they can't give consent. So as an adult, not only a mandatory reporter, but you're also responsible, because you can see the indicators, you know what is happening, you need to intervene, call the shots, and remove them from that situation.
Thank you. I will wrap up now, and I'd like to extend my sincere thanks to our panellists for their immense expertise and their diverse perspectives, and especially Julianna for your courage and for joining us today. So if we could give everyone a round of applause. Thank you so much, everyone, for joining us.